And I can take roll formally. Okay, Hartston,
Here.
Sarush.
Here.
Okay, we're all here.
Okay, great. Should we see if we have public comment?
Oh, yes. We have one attendee. So if you would like to make public comment, please raise your hand in the Zoom application. I don't see a raised hand, so I think we can proceed. I imagine other people are busy watching other things in our meetings today.
That's right.
That's what I'm thinking.
Okay, well, I did this. For some reason, what did I hit, Linda, to just make this look normal?
There's on the bottom toward the right, there's a little button that looks like a little screen. Little to the left, a little bit further to the left of that. Nope, you went too far. One more to the right, the next, that one.
Okay, great. Mission accomplished.
Okay.
I actually did the PowerPoint today, so it doesn't look very good, and I don't exactly know how to use it, but we'll make it through. Okay, so I wanted to start us off just going through our long list of topics, what I think are our topics and where we are. So we've got the whole issue of financial responsibility, which we're going to take up at the January 15th working group meeting. The continuing education recommendations, take that up at the working group meeting. Mandatory disclosures, we have the draft language pending the working group review. Scope of practice, same thing. Prohibited acts, same thing. Informed consent, same. So back, all being addressed hopefully at the January 15th working group meeting. On the list as we had it at the time, we also had advertising limitations and this large category of ethical standards. And we know subsequently we've talked a little bit more about what the process will look like for coming up with recommendations around rule and statutory changes. And I am meeting with Greg and the State Bar staff team on this topic tomorrow. So we'll be able to focus on this hopefully, or maybe it's Thursday or Friday, I don't know. Hopefully we'll be able to focus on this at the next meeting of this subcommittee. Today, my understanding is we're gonna focus on proactive risk-based regulation. So with that, I simply took some of the notes from Zach and inserted them into a PowerPoint just to kind of get us going here. So here, these are the this is the bulleted list of what the full working group identified as the objectives of regulating legal services. And I think it's important to keep building upon this, perhaps to take away from it, but certainly to keep coming back to it as we come up with a regulatory structure to make sure we continue to ask ourselves why we're doing it. What are we protecting from and against? Mm-hmm. So this is the list, and you guys have the actual Word document. Greg, I don't know if you have what I'm referring to, but I'm gonna, or maybe Linda, you can send him, Greg, the version that you made look nice. Okay. So at that session with Zach, there were really kind of two big risks that were identified. A worse legal result, so the outcome of the case is worse than it would have been had the next best alternative been employed, whatever that might be. And we kind of a number of things were identified as to how we might go about collecting data to help us assess whether or not this risk was in fact manifest. And the next one, which I think, Amos, is the one you wanted to focus on today, is the consumer overpays for the legal service. So the consumer is paying too much. And during our full meeting of the working group, we talked about the consumers paying for a service that would otherwise be free. So that's presumably the folks that would qualify for legal aid. And then you've got whether consumers are being overcharged for the services that are being provided. And then there were some other issues that we kind of briefly discussed around what is the consumer that the program is intending to serve? And is it in fact one consumer, or should we be talking about different types of consumers? And to that end, Zach Isles really has developed this risk analysis matrix that we didn't get to at the meeting. I think very briefly we touched on it, but you can see that in their model, they really are breaking out different types of consumers, individuals, low and high resource, and businesses to the extent that we contemplate that the paraprofessional would have any business clients. So that's really just what I threw up here for today. And I know, Amos, at least you had indicated you wanted to talk about fee caps. And I think that's speaking to this risk number 2 here, preventing overpayment. Just open it up for discussion now.
Yeah, so I'm fine with these jumping off points. I mean, I think for the first key risk factor, as I took notes or understood what the goal was in terms of next best alternative, underlying it was not just data collection on comparing, but also ensuring competency. And I think it's because it was based in a lot of the factor. I think it was, what kinds of regulations can be had to proactively encourage and enhance competency of services as well. In addition to sort of doing some sort of study and collection of data to evaluate.
Can you elaborate a little on what you mean, or maybe thinking about it in the attorney context? What do we have in place to encourage competency?
So I don't really claim to fully comprehend proactive regulation, but the materials seem to suggest, for example, continuing legal education is a proactive way to enhance or encourage compliance. Obviously, that's something we're already doing. I don't know what other models there are. Obviously, there's some sort of self-report, self-assessment that I think is proposed in some of the materials. And I think you sent around an audit from Ontario that had, I think, some of that component. But it sounds like, at least in the Colorado thing, there was like newsletters that contain proactive tips. But again, I don't have anything particular in mind. It's just that if we're thinking about proactive regulation for risk 1, I think this includes competent legal services, or that should be another key issue that we address.
Could we just stop there for a moment and discuss this, or at least maybe I need to hear from you? Risk-based proactive regulation as opposed to what?
As opposed to what we do now, setting aside an MCLE requirement. But right now, the bulk of our regulation or protection against risk, I would say, comes from a reactive complaint-driven process. So the state bar receives complaints, and then those complaints are investigated. Now, this is a generalization, because in some instances, right, the state bar will affirmatively open up an investigation because of a media story or whatever. But that is as opposed to, the starkest example is where attorneys are audited. And that's that Ontario report that you received. That's for the paraprofessional program. In Australia, the attorneys themselves are actually audited. So you're audited, and there's a desk file audit. And so you're not sort of waiting to receive a complaint. Instead, you're proactively going out and seeing what is the quality of what's being performed out there.
And have there been any evaluations of such a program showing that it leads to increased quality of services provided?
Well, I think what the proponents of this model would say is that it's a more comprehensive and sort of accurate assessment, because presumably you're either doing a random sample of attorneys, or as in Australia, they're targeting attorneys based on certain risk factors. Like they already know that if you're in doing estates and trusts, for example, that they receive a disproportionate number of complaints about estates and trust attorneys. And so they oversample them in their proactive risk-based regulation. Like we know there's potentially a lot of problems here. We're going to go out affirmatively and check. So it's not so dependent on the client having the wherewithal to file a complaint. So I don't, that I think that's the benefit of that model is, only certain people are accessing the state bar's complaint system. And this is not dependent on the nature of the client or the client having the savvy to access a complaint system.
Okay. And is this something that for the first time you want to try it out with the paraprofessional program or whatever we end up calling them? Or is this something you're going to implement to attorneys as well?
So the state bar is looking at implementing this for attorneys as well. Okay. And they issued, and I believe we provided it at some point in the May of 2020, the Governance and the Public Interest Task Force report that the state bar is mandated to do this report every 3 years, I believe, that focused on risk-based regulation. And actually, the same consultant who worked with the state of Victoria in Australia worked with the state bar in the development of that report. And right now, my understanding is there's a big data analysis going on to identify which case types might be appropriate for focus within proactive risk-based regulation, moving to more of an audit type of approach. So I think it's fair to say this is coming on the attorney side, but it's certainly not implemented yet.
Okay, my guess is you're moving towards family law, I'm assuming, or at least is one of them, right?
Yeah, I mean, I think there's certain areas, there's family law, there's criminal defense, there's certain areas where there's a lot of complaints, but then you're also needing to look at the sort of does the nature of the work itself generate complaints, because you always have a very disgruntled party.
Right, right. Okay, thank you.
So do you want to talk about this one, or do you want to talk about fees, or talk about both? Maybe we can step back and say, are those the two big risks that you see with the program? Worst legal result, being overcharged or paying for something that doesn't have value, or paying for something that actually hurts you?
Mm-hmm.
Yeah, again, I think for worst legal result, I don't know if the way this is framed that includes competency of legal services. So I would either expressly include that or include that as a separate risk factor.
Like incompetent legal services is the risk.
Mm-hmm.
Yeah.
Right. I was.
Is that really a risk? It seems like the risk is the outcome of the incompetent legal services, the impact.
We spent some time on this, I think, at the big group meeting. That's why I can go back. Like competency and protection of the public and consumer protection was separate from the next best alternative discussion.
So the risk is hiring someone who is not competent, not unknowingly hiring someone who is not competent, right? That's the risk.
Well, the risk is the outcome of, that you have a bad outcome as a result of doing that.
Okay. It's so hard to measure that.
That's what the harm would be. The harm comes from the outcome of hiring someone who's not competent. So I think that's captured in that you have a bad outcome. or you pay for services you don't need.
So that's interesting. I'd have to think about that, but I think that framing it that way changes how you might investigate it and regulate it. I think there's an ethical standard and obligation for competency that is that we can address in different ways than we would a survey or evaluation of outcomes. I'm not saying they're necessarily totally independent. That's why I don't mind if they're combined, but I do think the way this is framed, I don't think it captures a proactive regulation of competency issues necessarily.
To me, focusing on the outcome poses several problems. Number one, the outcome often depends on this, for example, in family law context, depends on discretion of the judge. So if an unfavorable outcome may not have anything to do with the competence of the paraprofessional, or it will be very hard to measure that. But at the if you look at it from the paraprofessional not stopping a client from entering a very bad agreement, 4-year marriage, yeah, waive spousal support. Because of the lack of competence, that's easy to measure. So I really think we have to be careful when we talk about this, is outcome of the case worse than if the person had hired an attorney? I'm understanding that's the question, right?
Well, it's worse than the next best alternative because there was a lot of push to get us to think that the next alternative for everybody is not a lawyer.
Or doing it themselves, or okay, got it.
Yeah, or not pursuing a remedy at all.
But Fariba, I think your point is well taken, because I think the issue with just focusing on outcomes may be that somebody may have very bad facts, right? So they're gonna lose. They don't get what they want in the case, not necessarily because of anything the paraprofessional does right or wrong, but because they're not entitled to it, or there's other issues. And so this also, it's sort of, how do you measure outcomes? Was it a good outcome or a bad outcome? One is a survey to see if they're happy and got what they want, but that may be not complete, because sometimes an outcome is good even if the client isn't 100% satisfied.
Yeah, and the way I understand it is, there are these duties that attorneys have, and as long as they perform those duties reasonably, then they're not in violation of those rules, right? Duty to, zealously advocate, duty to communicate, duty to perform services competently. Even if they lose or, don't get the favorable outcome, that doesn't mean they didn't perform the work competently. And
that's right. So I don't have a strong feeling if we combine the two or we do them separately, but I think the next best alternative is distinguishable from the competency issue that I think we also want to try to address with proactive regulation.
Are you saying, Fariba, you would recommend eliminating this as a risk factor? Because there isn't, if I'm understanding you correctly, it would be very difficult to assess, and that isn't really, the outcome is not necessarily the appropriate focus.
Exactly. I'm not saying to eliminate it. I think we have to monitor competence and encourage paraprofessionals to become competent. But what is a tool to use? Is it that we're going to audit you based on the outcome of the cases that you took, and then we're going to evaluate somehow that the result you got for your client was worse than if your client had picked the next best alternative? I just think that's so much work. It's so high maintenance. I can't even fathom how you guys are going to do that. Am I looking at this the wrong way?
I would recommend that we don't eliminate this goal, but I do think it's two different things. So maybe I revise my comments to add a third one on competency, because I think the next best alternative analysis may be important for at least program evaluation. to determine if we've done something here that is meaningful and helpful in addressing the justice gap, and there might be other measures for that. But, you know, are people better off than they would have been otherwise? Seems like a rational thing for us to be looking at. I just think it's different. I think we would approach it differently. It sounds like, Fariba, you agree with this, that this isn't necessarily the proactive way to address concerns about competence.
I don't think it'll measure competence accurately, and it's high maintenance, expensive.
So I could put up a blank sheet and we could start like mapping out competency. We could dig into this worst legal result, because I hear you, Amos, saying we should keep it, but I do think other than the, other than the surveys, sort of satisfaction surveys and impression surveys, this is a really hard one to assess. So we could, do you want to spend some time on this one? Do you want me to put up kind of a blank sheet and we can dig into competence? Or do you want to go to fees?
May I add one more thing before you answer? This is just reminds me that a compliant or a complaint-driven system is easier, because then you can definitely pinpoint the problem in the case. So people come in here, and I say this from real examples, that people come in here, the work that the paralegal or the document preparer did was clearly wrong, and it's really easy to see why that client, that litigant, lost or did not get their issue addressed, you know, and a good example is contempt actions. You know, those are highly technical. You miss literally one checkbox, the judge can throw it out, and should. So that's, if that person complains, it's really easy to determine what went wrong there, versus this proactive regulation where you would just at random sample paraprofessionals and to see what they did wrong among all the things they did. It just doesn't make sense to me.
So I think we can agree and maybe put in our recommendations that this should not replace the complaint-based system. And I think the discipline subcommittee is already well on the way to doing something parallel to what exists currently. So this would be to supplement that complaint-based system, to be proactive. And I think we should at least explore it. I mean, this, I don't know if we're going to talk about a random sampling. That's certainly one possibility, but I think we're going to be talking about audits and self-assessments and some sort of data approach that it can be evaluated, and maybe a basis to do additional trainings or something proactive. And I don't really see a downside to that, except potentially cost.
Certainly, if a pilot project is approved, which I saw a committee was formed, that's much easier. That makes it much easier to evaluate implementing such a system, because I'm assuming that you're gonna, we don't know what that's gonna look like, but it's gonna be a certain number of paraprofessionals, limited number. So it's easier to monitor it this way. And then if it works, it works. If it doesn't, then you would just go another way, right?
Well, I'm also a big fan of some sort of evaluation criteria, so we can confirm that it's working, which again may look like proactive regulation or fall into that bucket, or maybe closely related. But data collection and evaluation, I think, is important. And I don't know if you think that should be separate or if that should be within one of these, but I would want that to be I wouldn't call it a risk factor, but another goal of what we're talking about here.
Well, I think it's helpful to frame whatever data collection we're doing as either supporting an analysis of whether or not we're achieving the goals of the program, or are the risks materializing and or are we protecting against risks? So to me, data collection is inherent in this whole conversation because as you can see here, we've got surveys, we've got court record review, we have a work product review and data from malpractice cases. So it's all data. And so I do think just keep continuing to come back to what are the outcomes we want to achieve with the program and what are the risks we want to protect against? And the data collection ties directly to one of those concepts. So for this one, I do think there's a little bit of a distinction between the two of you. It sounds like, Amos, you would like to keep worst legal result as a risk factor, which means that there would be some sort of data collection or something designed to determine whether or not that risk was in fact present. I think, Fariba, you see that as a little bit very difficult to do and not necessarily that we should be focused on outcome, but you both are in agreement there's a separate risk, which is incompetent services. That's just a new separate risk.
I think that's right? Although I think I agree with Fariba on this one, the next best alternative. I think it's useful data. I just think it might be more focused on, evaluation of the program. Like, are people better off with a paraprofessional program than they would have been with whatever their next best alternative would have been, which is either an attorney or self-represented? That's useful information to have. Although I agree it would be difficult to collect, and it does seem like it is independent, although related to competency.
And is this, pardon me for being confused here, is this being used as a kind of a part of the regulations because that's our committee, or to evaluate? Looking at the outcome, asking that question. So for example, I'm envisioning some survey that asked the paraprofessional, how many cases you had, did, your client, did you achieve the goal of your client? Was your client satisfied? Then you would turn around, talk to the client separately, look at court records. Well, I mean, are we using it just to evaluate the program, or are we using those results of whatever we look at to discipline the paraprofessional somehow?
Yeah, that's a great question. And I think I need, and together we could get better educated about how proactive regulatory tools are used. Because my belief is that the results are not used to initiate discipline. They're used to inform other interventions. But the interventions are typically programmatic, meaning we've done this audit and we've seen that, 90% of respondents aren't doing X, Y, or Z well. And so therefore, we are going to develop this intervention or tool, and we will mandate it for everybody or for this population that we audited, but we're not going to use the results to initiate discipline. That's my understanding, but I very well could be wrong. And so I think that answers part of your question, Fariba. And then the other question is, it's a great question because program evaluation is part of the charge of this overall working group, meaning we have to come up with how we want to evaluate the efficacy of this effort. Well, you're talking about these particular aspects of that evaluation, so to speak, with your regulatory hat on, because we're very focused here on the risks we want to mitigate against. And that's regulatory in nature, not evaluative in nature. So I give this example. When we think about evaluating the program, we also want to see, is this a viable career for someone, right? Like, we want to survey these paraprofessionals. Are you making a living doing this? Right. Are you going to keep doing this? Is it really tough to get clients? Those are all things that we might ask in an evaluation. They are not public protection risk type of questions, though. They're like, is this going to be successful? Because people have to be able to make a living, but not, is this, are we protecting someone with these type of questions? So it's a bit of an artificial distinction, but I'm trying to have you guys focus on the things that are risk and harm that we want to protect against. And in some other committee yet to be formed, we're going to talk about evaluation.
Okay.
Yeah.
Okay, got it.
Well, with that understanding, there was one more, I think, that was discussed at the full working group meeting that I think is important. I think Fariba, you mentioned this one, addressing abuses currently going on in the unregulated industry. And that's, I think, fraud by non-licensees. Again, I don't know if that squarely falls under what we're trying to do here, but that certainly is a public harm or risk that could be created by this system, or that's a related that we could try to create some proactive regulation about.
Mhm. And then I heard, I might have misunderstood at the group meeting that my understanding was when this program developed and implemented, that those people who run a business doing similar work are going to be in violation, just like if somebody practices law without a license. But I thought I heard that committee, maybe it was the discipline committee, licensing committee, say no, people are going to be allowed to, do legal LDA work still, or choose to become a paraprofessional. Did I hear that right?
Yes.
Yeah, I think that it's a political question. And I think that I had initially thought that one way that the legislature might be engaged around this program, and also something that I think would be important to do, is that ultimately a paraprofessional program could replace LDAs, UDAs, and immigration consultants, because there's lots of concern about all of these actors and the lack of regulation over all of them. Mm-hmm. But as you may know, there's been many efforts over the years to eliminate the immigration consultant, but that's very controversial and political. And there's this huge amount of concern about anybody other than an attorney doing immigration work, period. So very early on in this effort, we got an indication that immigration law could not be part of this program. So that obviates the ability to sort of subsume the immigration consultant. Mm-hmm. And then with LDAs and UDAs, I think a smart recommendation would be to grandfather in existing LDAs and UDA, meaning they don't have to become paraprofessionals, but there would not be new LDAs or UDAs added once the program is up and running. I think that would be a smart way to thread that needle, because I think it's the right outcome, but they're a big lobbying group too. And you heard Elizabeth, like it's not their thinking that they're going to go away.
Yeah. The problem is, why would anybody be motivated to have to pay this licensing fee, having to comply with new regulations, when they can put up a sign and do whatever they want? We're not going to get rid of bad actors here if we allow that. So I'm not sure if this is the right place to mention it, but it's been weighing on my mind since the last meeting. And I wanted to just ask you, did I hear that correctly? When you look at immigration consultant legislation, nobody else can become an immigration consultant unless they comply with those rules. And I don't know why we can't have it the same, but not hearing you.
But I don't think the LDAs can do. They're not now allowed to do what we're envisioning for paraprofessionals.
But they would. I heard I forget her name, but I heard say some LDAs don't want to give legal advice. They don't want to represent in court, but they're doing all the other things, and they're doing them badly, and they're not regulated. They don't become competent. So my goal in joining this group was the hope of regulating that whole industry to eliminate the abuses, the bad actors. If they're allowed to, they will not become licensed, and they will continue to do what they're doing, and they offer their services as a lower price too. And the unknowing public will continue to be abused like that. I'm going to get down my soapbox. My apologies.
But I think, Amos, that item, I think it's here, bullet 4, creating protection regulation over unregulated services. I think that's what it's referring to.
Thank God.
And again, I encourage the group, you can come up with whatever recommendations that you want to and think are appropriate. And it's only in the last probably 2 years that I think the state bar has really fully understood the full panoply of all these other legal service type of actors, because you know the state bar has nothing to do with LDA or UDA or immigration consultant regulation. So you can generate whatever recommendation you want to.
Well, I think that is one of the reasons why I think it's important that we do address this, because I think one of the criticisms of the bar creating this program is that it has not been actively involved in the problems with unlicensed legal services. That has been a real concern in the community for a long time around these other programs. So the idea is this could exacerbate that problem by creating a new licensees that could be, you know, trick people into forming, okay, I'm licensed, non-licensees basically. So I do think if the bar is going to create this program, we should seriously consider, again, I don't know if it's proactive regulation or other regulation, but dealing with the concern about the unregulated services.
And I like your recommendation, Leah. I think it's a really good compromise and may sort of deflate those who would argue against it by saying, okay, grandfather those people who are already doing this work in, but we're not going to allow anybody else to become new LDAs. This is the new thing. But then you would have to eliminate those who are not LDAs aren't doing this work. They call themselves independent paralegals, which are no such thing statutorily, right? But we want to eliminate that group. I don't have as much problem with LDAs because they are somewhat regulated. It's those other people.
The only thing I would add, the state bar has limited regulatory authority in this area. I mean, really, if you're talking about regulatory protections against folks beyond the LDA classification engaging in what we might characterize as the practice of law, that really falls within the legislature's lap. That is protecting the public, because that the state bar has limited tools that the legislature's provided to them for dealing with non-licensees engaging in the practice of law. And I think we've talked about them in prior meetings. And to the extent the legislature wishes to expand the regulatory authority of the state bar, they're going to need to act to do that. There's been some talk of that in the past, of allowing them to pursue non-lawyers engaging or suspended non-licensees engaging in the practice of law. But that's never really gotten much traction, just because of the limited resources available to the state bar. The state bar is funded by dues, by fees paid by lawyers. And so they can't just become a floating, prosecutor's office out there doing this kind of work. So it's going to be difficult to really formulate, I think, for you all, regulations to reach those individuals. I think it's really, it's the job of the legislature, and it's beyond the regulatory authority of the court, quite frankly.
And it's outside of the boundaries of the work of this work group? Or no?
To impose regulations that would allow prosecution of LDAs engaging in LDA activities or engaging in the practice of law,
or to solicit legislators or look for legislators or propose legislation. Are we not even going that way?
I mean, I'll leave it to Leah, but it seems like it's a bit beyond the charter of what we're trying to do right here.
I will say that the discipline subcommittee has been really interested in UPL, right? And we did hear from someone in the LA County District Attorney's Office, as well as the supervisor of the unauthorized practice of law unit in the Office of the Chief Trial Counsel, to talk about what Greg is basically saying, which is the very limited tools available to the state bar, and then how under-resourced the DA's offices are to deal with the referrals that they are getting from the state bar and all of the other situations that are known to them. So that subcommittee is really interested in this issue. The woman from the DA's office did provide some pretty concrete recommendations about statutory changes she would like to see to kind of enhance the DA's office's ability to prosecute these cases. I think there's an issue where, I don't know if you remember Greg or Linda, but they can only prosecute them as misdemeanors. She wanted ability to charge felonies in certain situations. So that subcommittee is interested in generating recommendations in this vein, even though it is outside, I think, that the charter per se of this working group. So I certainly think we could arrange for a joint conversation and have a session focused on recommendations in this area. It is really outside of the state bars. Our abilities here are really hamstrung, really limited.
Mm-hmm.
I'd be interested in that. And I do think there's some obvious presenters, but it sounds like the discipline subcommittee may have heard from some of them. But yeah, I mean, I think there's people who are very familiar with the concerns that exist currently over sort of consumer protection, unauthorized practice of law, fraud, and we've heard a lot. I think this is the basis that a lot of legal services organizations are just against this concept of a program altogether because of concerns that this will increase. So I'd love to see us address it if we can.
And I'm just keep remembering the immigration consultant legislation. And I had the opportunity to go back and read some legislative analysis documents that were available. And the concerns are exactly the same. It's all about implementation of a new program in a safe manner where we don't put consumers at more risk or that similar risk. I'm hoping that we can eliminate some risk and abuses by working so hard to come up with these, these rules and regulations and I don't know, whatever else we're working on.
Well, Fariba, I mean, not to get completely off track, but I mean that these concerns date back to the late 1800s when before the state bar even was created. Yeah. If anyone could really hang out a shingle and say they were a lawyer, and that was one of the reasons the state bar was created, but it also prevented people from entering the legal profession. So it was a market regulation in many ways as well. So I think anytime you create a licensed professional and create standards that they need to meet, you're always going to have the danger that somebody's going to hang out in the shingle and say that they are that, and they're not. I don't think we can escape that really.
Mm-hmm.
And I think other license boards, sorry if I'm saying that incorrectly, but in California deal with the same issues like licensed contractors, right? I think they feel like they have, unfair competition from unlicensed, not bonded professionals, and it's hard to deal with. I don't know that the state contractors license board has an effective remedy for that.
I'll say one of the things that always occurs to me when I hear from a lot of the people that have very valid concerns about going down this road that it would create cover for these fraudulent actors, what always occurs to me is, are we saying that by creating this new profession, we are going to be creating new fraudulent actors that would not otherwise be out there preying on people? Because it seems to me that the people that are wanting to engage in fraud are going to do so whether or not we create this profession or not. They're going to find some way to do that. And it always strikes me as not a very strong reason to not pursue this program.
No, I'm not saying that. I'm saying
No, I know
that,
you're not saying that.
you know,
I'm just saying that,
Yeah.
that's something that always occurs to me because when we go down this road, I have a hard time accepting just personally that by creating this new licensed profession, it's going to lead to a larger amount of fraud than already exists in the system.
Mhm.
So-
I suppose I'm saying that a little bit because I'm saying if somebody is starting off on this new career, they're choosing, oh, I really love the law. I can't afford law school. I don't want to study that long. Oh, there's this paraprofessional, but I can do almost the same thing outside of the program without having to, like I said, pay a license fee, having to adhere to all these rules, and I can make money. You see, I'm not, I hope I have more trust in people than that, but I'm just thinking, I'm putting it out there for us to consider in terms of regulating the entire field.
And
Right.
I totally agree. I totally agree. And but it sounds like the discipline committee is because what that would be, I think, is the unlicensed practice of law. And that is already illegal. The problem is it's under-resourced, right? So maybe what we do is we advocate for more resources for that, or for whatever the law enforcement people are saying they need, what tools they need. And that may be the best way to address it.
But it acts as a deterrent to good people. You know, I think Greg is right, is that if somebody is a bad actor, they're going to be a bad actor regardless, you know. But if somebody's making a choice, a true choice, a good person, and it's just a matter of economics and time and all of that, right? If we give them a choice between getting a paraprofessional license and being able to do exactly the same thing, but the hard ones, right? Representing them in court and giving legal advice. And then they don't have to adhere by the rules of professional conduct and all the regulations and things like that.
Yeah, I don't know. I think, these folks are going to be listed and searchable on the State Bar website, just like attorneys are. Courts will receive like education and training about there's a new class of licensees. Here's what they're authorized to do. We encourage you to go on the State Bar website and make sure that the person who's appearing before you, assuming some kind of in-court representation is allowed, is actually licensed. So I think there are going to be there's an ability to build protections in once you have a truly regulated class of folks.
Including some of the suggestions that Amos, that you made about the disclosures and informed consent that need to be obtained at the initiation of representation. I think you include in there what will be the equivalent for paraprofessionals of a State Bar license number, so people can actually look them up.
Yeah.
And having those numbers on all submissions to the court, so the court can make sure that they're licensed as well. There's
That's
ways.
right. Maybe advertisements too. Yeah.
Yeah, and the State Bar is getting a lot more savvy about using social media, and that's part of another to do with the working group is like the outreach and public education. The fire is going to be like, look these folks up. Don't hire someone if they don't have a number.
Yeah, and I think like licensed contractors have to put their contractor's license. I think most licensed professionals need to provide that in their advertising and in their contract.
That's
And I
right.
hope you have a paraprofessional referral service, just like you have lawyer referral service.
I think they probably will be folded into the lawyer referral service.
Yeah, and then
They
we
would be
can,
separate
as a
ones.
court, can refer people to your website as we do now
Yeah.
for lawyers.
Do you
So-
want to move to competency or fees? Just looking at the time.
I like
Yeah.
fees. I want to see what Amos has to say.
I don't have a silver bullet here, but I agree with the risk factor. Yeah, and it sounds like, just to be clear, it sounds like we now have 4 risk factors, right? The competency, excessive fees, the next best alternative, and then including something maybe combined with discipline on this, creating protection regulation around unregulated services or unlicensed services. So yeah, so for fees, I think I prefer a bright line, regulation to say, here's a fee schedule or here's a fee cap. But as an alternative, or maybe combined, a proactive approach, it seems to me, is to ask for data about what fees are being charged and monitor that to see if, how much people are paying for paraprofessional services, and to see if there needs to be some sort of proactive, is this really as intended a lower cost alternative to hiring a lawyer? And it seems like we could create, we could choose, I think, or do both. I don't know if a self-assessment or self-auditing about what, will necessarily uncover somebody who's really overcharging significantly. There might be ways to hide that, but, we can get sophisticated about that.
Are you saying that at the outset, not have any fees regulation and just through the pilot program evaluate it? Is that what you said? I'm sorry, how are we going to do this?
So in my mind, and this might not be the right analysis, but in my mind, there's really two different things. One is a bright line regulation rule that we create that is a fee schedule or a cap or something like that. I don't know if that would be considered technically proactive regulation or not, but that is an alternative. That is something that I know we don't agree on that at this point, but we're sort of have been discussing that might be one way to address this risk. It seems to be another way is, and I think they can work in combination, is what I think of as proactive regulation, which is, asking for mandatory reporting of what fees are charged for what services, and to collect that data and then determine if action needs to be taken either with an individual provider or more globally.
And I think in the beginning, when we were kind of discussing the topic in general, we talked about kind of getting some information about, for example, in family law, for what services can a flat fee be charged, what services have to be hourly, such as, and I think we had some discussion, I'm recalling this about, if we're allowing for a presentation in court, that's going to be hourly. It's really hard to determine a flat fee for that. Depends on the degree of disagreement between the parties and so on and so forth, versus when there's like a simple default judgment or default divorce, that's going to be more controlled, or a summary dissolution. What are your thoughts on that in terms of kind of looking more detailed as the services and try to ourselves come up with some sort of a recommendation as to, oh, here's what, you can charge flat fee for this, you need to charge hourly for that.
So I think where I am currently, although I can probably easily be moved, is that I would like to encourage flat fees, but not require it, right? So I think a flat fee would be a really good development if it were available for some of these services, but I don't know that we should be requiring it. And then for hourly fees, I think that's the standard hourly fee for services. My concern is that they'd be excessive. Either the hourly fee is charged or the number of hours are charged, so the total fee becomes very excessive and a lot more expensive than hiring an attorney would be. So that's really what I'm trying to protect in. I do think where I ended up in my last recommended language, if you remember, on this, is I tried to put something together, and it was sort of like a, keep in mind when setting your rates, it's supposed to, the intent of the program is to be a lower cost alternative, but that's not a disciplinary rule, right? That's just a sort of advice. So I just don't know. I think I would be most comfortable with what's on this list here, a price list or fee schedule or statutory fee, or just as a comparison, as a presumptively, unreasonable if it's above this or something like that. I would be very comfortable with something like that. It'd be hard to develop, but even if it's on the high side, I think I'd rather have that cap than unregulated. But I think there's two separate questions in my mind, which is, are we doing some proactive data collection? Say, what is your hourly rate? What have you charged for this? What's the highest you've charged? How do you set your fees? And have that data flowing so there can be some analysis of it. I think could be helpful as well.
Do we have data from LDAs right now, how they're charging by any chance?
We have the survey that I think we've shared with the group, or it's in the Dropbox. Elizabeth shared the CALDA survey with us. I'm saying the CALDA survey, a survey I believe that was done in 2019 or maybe 2020. And I think it had 70 or 80 respondents, and they shared their fees for certain case types. And a lot of it was flat fee. But there's no parallel kind of reporting requirement for anybody.
Yeah.
And I was going to ask Greg, what is the rationale for not having fee caps on what attorneys can charge?
I think it's just there's a lot of people have very strong feelings about allowing the market to regulate the fees. So I mean, I have never done a deep dive. I know that the rationale for the statutory caps that we see really, again, it comes through a legislative process, and like with workers' comp, we saw long period of well, that system was just breaking down in a lot of people's assessment, and that lawyers were overcharging and churning cases, and so it seemed like a reasonable regulation to set statutory caps on those types of cases. And we've seen that also in other areas like MICRA, but those are really political decisions and focused rather than on the profession. It's focused on that area of law and trying to tamp down the cost of litigation rather than putting caps. That's one thing I was thinking. There may be areas in which these paraprofessionals are practicing where it makes sense to have a fee schedule. Like I'm thinking of collateral criminal. If there's an expungement, if there's a way that you can come up with a reasonable fee, I would imagine a lot of the potential clients are not going to be people of great means, and it's a fairly. I think one of the reasons it works, I'm sure some people object to this, but it works in the workers' comp context is because it's somewhat clear process that you need to go through in order to get a final resolution. And so the caps really operate based on how far the attorney has to go in that process. And I think that some of the things that we're contemplating paraprofessionals can do, will be allowed to do, would lend themselves to that kind of cap. Other areas it may not. I mean, I'm thinking in family law also, it really depends on the litigants on both sides and the dispute and how long it's going to go on. So some areas may lend themselves to caps, other areas may not. But one thing I wanted to just suggest, because interesting to me, the idea of audits, and I think one of the obstacles that you're going to have is you're going to have clients be willing to waive attorney or paraprofessional client privilege in order to really do a thorough audit to investigate how competent they were in terms of the services they provided, or whether or not they provided a satisfactory legal income and outcome. And I think that you might be able to, that may be a good avenue to go through the clients to get them to agree to this audit and tell them what the objectives are. But as part of that audit, you can check and see, were they charged the amount that the paraprofessionals say that they charge? Because I think you might have paraprofessionals that have what might show you a rate card, and that may or may not be true. And it's very difficult to check that without going to the clients and asking them. But really, to the extent that it starts to intrude upon confidentiality, you're going to need to get a waiver from them as well.
And the paraprofessionals would have to reveal the names of their clients and contact information. That's going to be required.
Well, I think if you make compliance with an audit requirement and it being contingent upon the client being willing to waive confidentiality for that purpose, for that limited purpose, I would believe you could compel a licensee to give that information if the client is on board.
So I think these are really good points. I think there might be some alternatives, but I actually like that approach better. But I think audits could be anonymized, right? So you could say, you know, what's the range you've charged without necessarily revealing privileged information. So just on a mandatory reporting or audit, actually, let me say audit separately. So mandatory reporting, I think you could collect information without necessarily getting client consent. On an audit, if an audit is viewed as we're going to go in and look at your books and records and see what actually happened, then I think absolutely there's privilege issues there, assuming a privilege applies, which I hope it would. But again, I don't think that's a bad thing. I just think that means we'd have to put in a process to get consent.
Like the idea, because I also think it could be in the agreement. It could be one of the mandatory disclosures that the state bar has a program to monitor how much we're charging, because we're supposed to charge reasonable fees. And if I get audited, I may be asked for your information. I think it's a great kind of public consumer protection message, actually, to say that, you know, state bar is doing this. I might get audited. I might have to give your information, and you'll verify what I charged you. It keeps me honest. I think it's a nice idea.
I also like comparing this to the fee schedule imposed on workers' comp cases and how they came up with the whole schedule. I kind of understand what you said, Greg, in terms of the certainty of the process, and there's not a lot of unknowns. And I think you're absolutely right. For example, expungements, there's just, a limited number of hearings. I think just one. The paperwork is limited. Comparing that with family law, just up to the top of my head, is summary dissolution. It's like 5 forms. Parties have to be in agreement. It's just not complicated. So we could definitely come up with a list for each area of specialty that we're allowing. How hard that's going to be to come up with a list? Do we want to, kind of go through that effort, and then how to come up with a number, a dollar amount? And
will it vary regionally? Because
that's
the cost of living is, and there's lots of concerns about the workers' comp rate, that it's so low that attorneys take on hundreds of cases in order to make a living. So we want to avoid that problem.
Yeah, I was trying to say, I probably didn't do that as eloquently, but there are a lot of people that have a lot of criticisms of the caps and workers' comp, and that, as Leah said, it's really led to these attorneys that the only way they can sustain themselves is to have 350 active cases at a time. And that creates a whole nother panoply of potential consumer protection problems. So it's something that needs to be considered. The proponents are the ones that say, yes, we can figure out what each step in a workers' comp case is, and we can put a dollar amount around that. And I'm sure a lot of the practitioners will say it's not that easy. But there are other areas where it may be easy, and that's why I was mentioning collateral criminal, because I think from what I've heard so far, it really is a form-driven process. It's a discrete timeline in terms of how long it needs to get done, and so it may lend itself to a flat fee.
Name and gender change might too.
Yeah.
Right. So, but I like how it, something like this, if we do it for the paraprofessional program, it sort of parallels what we're doing with, or is being done with, the attorneys, right? Certain areas are regulated, fees are regulated. So I like that consistency. It's going to be a lot of work. There's going to be criticism. It's, and then how many fees will you have? For workers' comp, are there different fees for Northern California, Southern California, so on and so forth?
I'm not sure. I'd have to look into that.
Okay.
I don't think so. I think it's a percentage.
Which is another criticism, I'm sure.
So cost of living is not figured into it, right? And cost of running a business in San Jose versus, San Francisco versus Modesto, it's just not figured into that, right?
No, I don't believe so.
Or should it? you know?
I mean, perhaps.
I think we'd get so much criticism, and rightfully so, because it costs the cost of living in San Francisco versus San Bernardino. I mean, you just can't ignore it, right?
Because of running a business too. I mean, if you have office space, and I know we're in the middle of pandemic and office space is the old way of doing things, but really, it's just, that has to be considered. I think it would be unfair, but apparently it's not.
So my concern is different. So I think if we could figure out a way to do that and parallel workers' comp, I think I would be supportive of it. But I think my concern is a little bit different, which is people just being charged very high, several $100s an hour or thousands of dollars for something that just shouldn't cost that much. And they could get a competent attorney to do it for less. And it seems like we shouldn't have to go item by item or task by task to create flat fees or separate regulations for that, but just sort of, and this is why for me, the parallel is statutory fees, or some, courts have in some areas like family law or probate or criminal appointments, here's what an attorney gets per hour. Or here's a cap on the total amount without getting a court order to go above it. And just some sort of guidelines, I think, would be very helpful to address this risk factor. And, maybe it needs to be by county, maybe it's just the bigger cities, because those are usually the more expensive one, whatever. But it seems like we're going to have a paraprofessional board that could be in charge of this, that could adjust it. And I don't know that we have to make it overly complicated to put some sort of regulation that addresses this risk factor.
Or leave it as simple as, I think what Leah suggested earlier, a disclosure statement in the agreement, in the contract, that says, if you think here's the rule, I'm supposed to charge a reasonable rate. If you believe my fees are exorbitant, then here's a number to call. If you think my driving is bad, how do you call 1-800 whatever, right?
So I don't mind the disclosure, but I think the step before that is identifying what is a reasonable rate. Like what would be a reasonable rate? And would it be okay if somebody charged $500 an hour to fill out the court forms for whatever it is? And if we don't have any regulation, we don't regulate attorneys that way, right? We don't have even a reasonableness rule. It's the unconscionability rule. And attorneys do charge incredibly high amounts of money when they go to court, and there's a court looking at it to say, is this a reasonable rate? Often their fees are reduced to still high, but more reasonable dollars. But here we are at the regulation stage. So if we have a disclosure that says I'm supposed to charge reasonable rates, I mean, right now that's not a regulation. We'd have to create that regulation to say you have to charge reasonable rates. And what does that mean?
The only other regulation for attorneys that I would mention again is mandatory fee arbitration.
And Amos, does reasonableness, when I was talking about the disclosure, I was talking about a little bit more in line with Greg's suggestion, or Greg's concept of an audit, that you disclose that you as the paraprofessional may be audited, and that's something that's going to keep me, as if I was talking to my clients, it's something that's going to keep me honest with you. Like, I'd use it as an advertising tool, frankly. Like, whatever I say I'm going to charge you is what I'm going to charge you, and it's got to be reasonable, because I'm going to be audited by the state bar, without defining reasonable. Because my question, Amos, is that in relation to anything else? Like, if an attorney in San Francisco, I think the hourly rates in Clio, I can't remember what it was, but it was over $500 an hour, average hourly. So if you're a paraprofessional and you're charging $250, just making this up, is that unreasonable because we don't think paraprofessionals should charge that much? Or is it, well, it's half of what I would have to pay if I was going to hire a lawyer? So I think it is reasonable. I'm the client. I actually think it is reasonable. Like, how do we determine what amount is too much?
Mhm.
And is it in relation to something else?
So this is exactly why I think this risk factor belongs on our list, and we have to critically think about it, because the issue is, if there's no regulation, you're going to have some people charging $50 and some people charging $750, and no regulation and no consumer protection. So I don't know that I have the right answer, but I think if the point of this program is creating a lower cost alternative to attorneys, that there should be regulation about what appropriate fees are to protect against this risk factor. So I don't know what the Clio system is you're talking about. I did do a little bit of research on one of our prior calls and looked up that there are some fee schedules that courts, superior courts, create for when courts appoint lawyers. They require them to have malpractice insurance, and then they say, here's the hourly rate you're going to get paid. If you want to be appointed, you got to agree to this. And they're much more, I think, in the $100 an hour.
It
range.
is.
But
Yeah,
I'd be very concerned if there was somebody charging $250 or $500. And that's why I think, if people aren't startled by that possibility, that's, I think, the sign that we need to have some regulation about this, because if we don't regulate it, it's likely gonna, be a problem.
Mhm. But I think that I think we're talking about two different things with the superior court fees. I think there's a little bit of public servant aspect to that. Like if an attorney, I can only talk about family law, but if an attorney is appointed to represent the minor children, for example, that's a service that they're doing for the family, for the children, for the courts. There's some sort of a difference. It's just different. When we're talking about regulating these fees, I think you cannot help but being arbitrary. I mean, how do you determine 250 is a reasonable rate and not 150? How do you determine what somebody should charge in San Francisco versus somebody in LA? I understand attorneys in LA charge, I don't know, maybe Amos, but $1,000 an hour, $1,700 an hour. Those celebrity attorneys charge a lot of money.
Right. So this is our task. I don't know if we will be able to come up with a recommendation or if our recommendation will succeed, but I think that's the problem. If there's no requirement that the fees be reasonable, if it's not in comparison to being a low cost alternative to attorneys, or if it's, well, attorneys range in the thousands of dollars an hour, so there's basically no limit on what a paraprofessional can charge. Then we've just, I think, and it's possible there's no easy and correct solution here, but we're just then not regulating towards this risk factor.
But could the regulations say that and then impose an unconscionable fee standard like attorneys? Did you say the attorneys, that's the language, right? That the fees have to be.
Or discipline. So you have to, the regulatory tool that you're using for unconscionable fees is your license is in jeopardy. You might get suspended, you might get reproved, which is public on your profile on the website. You could, if you keep doing it, you could get disbarred. But we have other, that's what I was mentioning. We have other regulatory tools for making sure attorneys are charging reasonable fees or not overcharging. One is mandatory fee arbitration. The other is what we've talked about before, the State Bar Act, for legal services over $100 or $1,000, you have to have a written agreement, right? And if you don't have the disclosures in the written agreement, it's voidable at the option of the client. So that's something you can think about with the written agreement requirements that you're talking about, making it voidable on the client can make the entire contract voidable, in which case, you would, the attorney would have to probably, seek reimbursement just based on the legal services provided. And that could bring you into the mandatory fee arbitration realm.
And who determines and how is unconscionability determined?
Well, there are those factors. It's not, just so you know, This rule is not enforced frequently. It's usually enforced in conjunction with some other form of misconduct. And it's a lot of times it's revealed in the course of an investigation that they are charging unconscionable fees. It does come up, but it's usually the tip off is that there's been some complaint that an attorney, for example, is engaging in elder abuse and maybe drafting a will where it provides them a testamentary gift.
Okay.
Violates a different rule, and then in the course of the investigation, they determine that they're charging an unconscionable fee. But the rule itself has a number of factors that are considered, and they're really just taken from case law, from prior cases.
Okay.
It's rule of conduct 1.5, is that right?
Yeah, I believe so. Yeah.
So when I last time when I put some language together for us to discuss this, I based it off of that rule.
Right.
So those factors, I think, we could also address them. But again, I don't think that is an effective regulation of overcharged fees. If we just say, look at what the rule 1.5 says for attorney. First of all, most of those factors don't apply, or several of them I don't have in front of me, but several of them probably don't apply to.
Yeah. I think one of the things that might be helpful is to sort of unpack what we mean by an unreasonable fee, because there are different ways in which they can charge an unreasonable fee. Either they charge a fee for a service that's not provided, or they may have a reasonable hourly rate, but they're churning the case. They're engaging in motion practice or taking the client down avenues in the course of the case, in the course of the representation that are unnecessary. And so it inflates the bill, or they're just charging too much for an hour, or more than what's required for a flat fee for that particular type of service.
I want to mention the Clio report again, because so Clio is a law office management software program, is my understanding.
Mm-hmm.
And I'm just on the website now, because when I engaged with this before, it was the 2019 report, and we reached out to them and they actually gave us disaggregated data for some of our bigger metropolitan areas, which is why I remember this $500 for San Francisco. But they've got the 2020 report. So this is just all attorneys that use the Clio system. So it's not, every attorney in the state. But so it's 2020, the average hourly rate in California for an individual lawyer is $338. So that's statewide. And then it says a law firm hourly rate is $308. So we're the second highest in the country after New York, not surprisingly. But I'm wondering, because we don't collect the data for attorneys, it feels problematic for me. Like, it's unconscionable, it's unreasonable. But if it's significantly less than what attorneys charge, who are we to say that it is unconscionable or unreasonable? Like, if it's a lower cost alternative, but it's still more than we think it should cost,
So that, and again, I think it's a definitional thing, but I think I come from a different starting place, which is it's not a lower cost alternative, and that's the problem. And it's not, I don't think the comparison should be large law firms in big metropolitan cities. And again, I can see the counter argument, let's let the market decide, but I think our job as regulators or in creating a licensed professional is to address this risk factor. And the obvious way to address the risk factor is to have some limits, reasonable limits, and we can debate about what those reasonable limits should be. But I would be I'd be sad that I voted to create this if paraprofessionals were out there charging $650 an hour, because there are some attorneys that charge more than that. So they can justify it because they're lower than the average law firm attorney in San Francisco. I think that's just a circular nonsense that doesn't address the underlying risk factor of the purpose of this program is to have a lower cost alternative. And so we should have some, it might not be easy, but we should have some way to identify and define what a reasonable fee would be, and to have some sort of discipline around that.
So let's say okay to that. without condition. Next step, what do we do? How do we start? Amos.
So I think my preferred approach would be similar to the court fee schedules, right? We'd have to adjust them, and it sounds like maybe even regionally, and have the board in charge of that. But you know, I think it depends on what the practice areas are, and we'd have to probably gather professionals from those practice areas and create some sort of schedule that could be adjusted, and just have some sort of outer limit. I mean, those even might be high, and we're hopefully people will charge less than that. But that would be my preferred approach, because it's a bright line and it's easy to enforce and it's easy to regulate. But I think I would also be in favor of a system that just advocated for paraprofessionals to charge reasonable rates as a lower cost alternative to attorneys, and then have them be presumptively unreasonable if it's not, and have some sort of standards around that. I'm not tied to any particular way of doing this, but I just think I think we're not being honest with ourselves that what we're doing is creating a lower cost alternative to attorneys if we don't have any regulation around this.
So the Superior Court fee program is for attorneys. How would you use that to set rates for paralegal or for paraprofessionals?
So it'd be a cap, right? It needs to be lower than this. And those we don't necessarily need to use those existing schedules. We could create our own. But for the particular practice areas, I mean, it might be different for family lawyers, or it might be different than housing, or it might be different than the collateral criminal. But it would be like, this is supposed to be a lower cost alternative. Here's what we determined, somebody could go out and get an attorney for. So that's a cap. It needs to be lower than that, presumptively, right?
What about the idea of saying, one, collecting the data from attorneys? Do you all think we should? And two, I come back to the Clio thing, because if the average statewide is 300 something an hour for a lawyer, not a law firm, in terms of the overall evaluation of the program, let's just start there. Would we say we don't want the average paraprofessional rate to, certainly we don't want it to be over that, right? If the lawyer is $338 an hour in California, most certainly this paraprofessional average hourly rate needs to be lower than that.
I would go with something like that more than tying it to the court fees. I just don't see the rationale, but I do see if the Clio data is reliable and recognized, or whatever else we use, something having to do with private professionals, not attorneys appointed by the court, totally different sphere. So I would totally be okay with that, that's anything above that certainly, or anything at that rate or over would be considered unconscionable under this regulation. Tying it to something that is free market, out there, rather than court-based.
So I totally get what you're saying. The court-based might not be the schedules to use. And it sounds like if we wanted to go down this route, we'd have to create our own schedules. I totally think that makes sense. I'm not familiar enough with the Clio data, so I shouldn't necessarily take a position yet, but my preliminary thoughts on it are strong, which is, I think we're fooling ourselves if we think that is a rational measure to either for discipline or caps or for evaluation of the program, which I do think are two separate things, but obviously related. But if we're happy that paraprofessionals aren't charging $1,000 an hour, I don't think I don't think that's a useful evaluation. And even if it's 500, I'm just saying 1,000 because we do know attorneys charge that. So that might not be the average rate, but if you're looking at, large law firms in large cities, it skews the numbers significantly to what we think this program is, I think, this program is really designed to do. So that's why I say that the court fee schedules might not be the right numbers for the reasons you point out, Fariba, because either it's a service or they're looking for low cost attorneys that it's lower than market rate, et cetera, et cetera. But the idea is it should be closer to the $100 mark in my view than the $500.
Do you know the lawyer referral service, for example, in our county is right now in trouble. But anyway, when they were fully functional, they had a modest means panel. And the attorneys had to be on that list. They had to have malpractice insurance and had to commit not to charge more than $100 an hour. Is there something, you guys, statewide? Modest means panel in every county, you know?
They all have their own separate rules.
Okay.
Not every county has it. I was checking in with the San Francisco Lawyer Referral Service, and there the only requirement is that the attorney, if they take a case from the low fee panel, they have to agree to charge substantially less than their normal.
Substantially. Okay.
Yeah, and
Not
that there's not any specific amount.
And there are a lot of court cases, by the way, that talk about reasonable attorney's fees. But again, they're usually pretty high, right? It's like in class actions or where there's fee shifting statute. A superior court or a federal district court will get involved and usually reduce. So an attorney will say, I regularly charge $600 an hour, and they'll put in declarations, and the court will say, okay, but I don't think that's a reasonable rate. Reasonable rate is, $350 based on, these different factors. It's not an easy thing. There's not a schedule out there, but the reasonableness of rates is something that courts look at all the time for attorney's fees. So the issue for me is, as a regulator, I think we want to make it as clear, simple, straightforward, fair as we can, both in protecting the public, but also in making a livable career path for paraprofessionals. And so again, I don't know that there's going to be agreement, but I think a fee schedule would be the easiest, clearest, bright line way to do that, but there may be other ways to do it.
So my thinking was, if we're saying that this program is being developed as a low cost alternative to hiring an attorney, and if we can find data from different counties, that's 50 counties, about whether they have a modest means panel program and how much, and kind of average that out and use that as a basis.
I think that's fine as long as it's the right practice area, right? So I think the idea would be, if there's a family law attorney, you might know this certainly better than me, but in your county, how much would it cost if somebody needed an attorney to do some of the things that the family law group is? And I'd be surprised if you came back and said $350, $500 would be required, because that's the average rate of attorneys. I don't think that's the right approach. And there may be other ways to identify sort of what's the right amount to set. And I agree, it might need to be county by county, or, I don't know if we need 52, how many counties are there? 52.
58.
58
Yeah.
different ones, but there might be regional, or there might be, ways to do it, because the larger cities are going to be higher. Right. And I don't even know that I need it to be so particular to the county. I just don't want people charging, outrageous amounts without any regulation at all. It's really my concern.
So Leah, that could be our next project, developing hourly rates based on regions for different practice areas. Leah and I have some experience in doing this.
Yeah, we set all the rates for dependency council statewide together like 15 years ago now.
It's not an easy task.
I remember that.
Can I ask you seriously? I mean, what was your methodology for setting that? Because that's
I can tell you about that. It was a complex task. We started with a study that had been done a number of years prior for the cost of what is it? It wasn't the cost of it was the cost of labor. And then we looked at, we developed different regions, and we developed the cost of labor. We looked at we tied it to county council salary. we looked at household income to sort of develop statewide regions. But then there was a matter of tying it to county council. But I think if we were going to do that for, I think there would be a similar methodology for developing regions. And I don't think it would be county by county necessarily. Although that led to conflicts because there were some counties even, and I think this is the challenge with the regions, that like Santa Barbara County, the attorneys there got really upset that we shouldn't all be getting paid the same rate because the cost of living in southern Santa Barbara County is, 4 times as much as the cost of living in northern Santa Barbara County. And so I think there are real challenges there. And this was court-appointed counsel and these were government funds. And so we could sort of dictate it. I think to have a free market and to have a regulatory agency imposing fees on people who are practicing in a free market, I think we'd be facing a lot more challenges.
Yeah, although I wouldn't say there's a fee. I think it should be a cap, right? I think it should be needs to be under this, and it might be rather high cap. But the idea would be this is designed to make sure this is a lower cost alternative.
I mean, so one of the things you could do is you could sort of figure out what's the average hourly rate or flat rate for attorneys practicing in this region for this area of law and say the cap would be 75% of that rate. I mean, that's just sort of throwing something out there.
That's what I was saying is that let's figure out what that is. And we don't have to do it average statewide. We could do it by region.
But we don't have the data.
Right.
So the Clio report I'm going to send to you, I just looked at it. It's like several thousand, represents several thousand attorneys nationwide that use this Clio case management system. But there is no requirement to report your fees to the state bar. So in doing the dependency work, government attorney salaries are public. And there was this intentionality about pegging this rate to county council because of concerns about the disparities in the courtroom between county council representing CPS and then this dependency attorney who makes nothing and has to take 10,000 cases and like it's not a fair fight. So that was the rationale there. Here, it would be really challenging. But I think because it's past our time and we all have to see if we're at civil war right now in our country, I think we can certainly try to get information on modest means panels. Like we can see what information we can find on what attorneys are charging out there. What information can we dig up?
And what about if we tried to peg it like you did with dependency counsel for the government lawyer? What if we tried to peg it to like legal services or something similar? Because again, I think this discussion is skewing rather high in terms of if you're looking for average rates of private attorneys in law firms. I'm just not sure that's the right.
But legal services attorneys, they don't have an hourly rate. They're providing pro bono services.
Right, but they have a salary and you can figure out what their hours.
Well, I have a salary, but it's just it's apples and oranges. Would it be totally out of the realm of possibility to send a question out to attorneys, asking them how much they charge, kind of categorize them and asking them how much they charge?
I don't think the state bar would do that.
Okay.
I think. What do you think, Lee? I think it's highly unlikely the state bar would.
I feel like in this big census we did right when I first got there, we did ask. I'm gonna email Ron after this call. I feel like we did ask it once. I don't know that the state bar would be so controversial, but I think it's really important because I think it would be good to know what attorneys are charging out there because we just have no idea and we're the regulator.
It's good information for the public.
I'm
not tied to this program. Sorry, Greg.
And that's okay. I'm just not sure that's the best way to find out because I would look askance at whatever they're self-reporting as what they're charging as compared to what they're really charging.
Right, and the attorney sense it's voluntary, so it might be a really skewed sample.
Yeah,
of the responses that we got.
Are there
forthcoming?
I know we're over time, but are there court records? So in other words, maybe in family law where you have to get court approval of fees because one party is paying the other fee, or for certain things or default judgments where you get a fee where the court's ordering reasonableness of fees?
There might be, but I think
Hard to-
to
it's
get at
hard
that,
to
it's not
find.
going to be in a database somewhere. It would mean someone spending time to do research, looking at individual files.
Yeah, yeah.
Or asking judges, right? I mean, again, we potentially could get family law, the presiding judge of family law courts from a couple different counties and ask them these questions as well.
Yeah.
As well as practitioners.
Twitter has locked Donald Trump's account for the next 12 hours.
This is
A lot
insane.
less views.
All right. Well, I think what we're going to, so tomorrow, Greg, Randy, Andrew, and I are meeting about the rules. And I think we're hoping to have a list of at least initial policy considerations for you all to be vetting for the next meeting of this group. And then Linda and I will dig up whatever we can find on attorney rates, what attorneys are charging out there, trying to turn the legal services. We do have average salaries for legal services. You need to add in benefits. You need to add in the overhead costs to try to approximate something. So we can try to do that.
They also do fee petitions, I think, and get, even though their services are free, I think they're entitled to.
The other thing we could tie to is paralegals working in private firms. And also our court has a category of clerks called court specialists. I have 2 of them that work for me, 3 of them who work for me. And I call them really highly trained paralegals because that's all they do, court forms, and they do DV. They do really similar work to what the paraprofessionals will be doing, but no legal advice, or of course, no representation, but they get paid a good hourly rate, which I can share if you all want to know, but we could tie it also to those kinds of work. I think private paralegals who work in law firms, like in family law firms, in the different areas of specialty we're looking at, maybe that's a good guide. What do you think about that?
Yeah, I agree.
How do we
again,
get our hands
You'll
on
see
that
in
data?
my favorite Clio report that that there is also non-legal, and I'm not looking at the details right now to see what that is, but I'm assuming that is going to be your paralegal hourly rate.
Mhm.
But otherwise, I'm not sure where we would get that. That's what I was going to say, Farida.
Well, why don't we look at what Clio has to offer?
Yeah, I'm excited to send you the link.
If there's nothing else, come on.
And maybe what you did for dependency attorneys, because again, I think whatever the methodology was may be interesting or helpful. And also, again, LDAs, sounds like we don't have information, but we could potentially ask. That might be less controversial, asking them their fees than asking for attorneys.
Okay. All right, Linda, I'm sure you will love to dig up the dependency council methodology.
I don't know where I'm at. I don't know that I have access to it anymore. I'll have to dig through. I don't know.
That was
just the
years
council.
of our life.
It was.
Fond memories, it sounds like. Well, thank you
Maybe
for
we
this.
could put out a call to LDA Association, to put out a call to their members to encourage them to share that information.
It's actually in the Dropbox.
There
There was a 2020 survey.
But how many did you say participated?
I don't know, but I think we did. There was a call for them to participate. I can send you the link to where you can see that.
I think it was like 70, and Elizabeth already encouraged them to participate.
And only 70. I don't know how many there are, but that's.
I think so, but I'm not sure. There's something like 4,000 or 5,000 they think in the state, but there's not any centralized repository where they're registered. But there's only, I think, 250 or 300 that belong to CALDA.
Okay.
If I could be wrong, but we'll get that. We'll resend it.
That's higher than 70 who participate in the survey. So I'm just thinking if they're motivated because, this new program is going to be set up and we're looking for really hard
We're
data.
gonna put you out of business.
Yeah, hey, hello.
We want to make sure we can undercut your rates. Should we say that?
Yeah, in a nicer way. Okay, find a positive way to say that. All right.
I think they'll be advocating for higher rates.
Yeah.
So for next time, thank you for going through the rules. I mean, I think that is critically important and maybe fun to only certain people. Are you planning on having presenters for us, or because I'm no expert in some of these are going to be tricky issues, I think, especially the fee sharing and the conflict rules, and I assume those are the types of things we'll be talking about. So maybe Greg, you could be our expert, or maybe we can have the State Bar staff back. They seem very knowledgeable about it too, and I'd love to hear, those
Yeah,
thoughts.
I'm happy to be a resource. As I told Leah offline. I mean, I probably should not be a presenter given my role with the Supreme Court, and I ultimately will be presenting the recommendations to the court. So I don't want to give you any indication that I prefer one policy decision over another when it comes to this. But I'm happy to answer any questions I can based on my experience on the Rules Revision Commission.
And we started to, Amos, via email, Greg, Randy, Andrew, and I identify folks to come and speak with you to help you walk through sort of the rationale for the existing rule, and then walk through some of the implications. So, and we'll talk about that more tomorrow.
Mm-hmm.
And a couple of names already were floated. So we'll make sure that happens.
Budgeted enough time, and because I know when we start talking, we may get hung up on something and then there goes the time. And I know with the rules, last time we stopped at, if I'm remembering correctly, where we talked about, making a general appearance and, the limitations on communication with the other side and substituting out. Yeah, I don't know if you remember, but then we got stopped. So I would just ask if we could budget enough time and have somebody, be the boss of the meeting and kind of move us on.
Mm-hmm.
I'm just talking about me.
Just so you know, so Randy and Andrew and I have gone through the rules already and tried to flag. We've categorized them in 4 different buckets, and ones that probably can be adopted pretty much as is by replacing lawyer with paraprofessionals. Others that will need to have a bit of fixing that is more just to conform with the contours of the program, whatever that will be. And then others are really going to be contingent based on the scope of practice, such as whether or not they're going to be able to represent entities as opposed to individuals, because we have a separate set of ethical rules just for that. And then there's the 4th category, and that's the one that Leah was referring to, where the underlying policy questions need to be answered first. So for example, with the conflict of interest rules, are they going to be permitted to practice together or with lawyers? Because that really starts to get into imputation of conflicts and ethical screening and things like that. And that's a big question that needs to be answered. So.
Okay. And we're going to have some material beforehand to get ready. Yeah. Homework for the meeting. Once you guys are done, right?
We're going to try. We're going to talk about it tomorrow.
Okay. Thank you. I don't mean to order anything. It's just would help me to get ready.
All right.
All right.
Look for your link to the Clio report.
I sent it already.
Thank you for all your time.
Oh, Linda, I was so excited to do
She
that.
is so quick.
Oh, no, I'm not the Clio report, the CALDA report. I'm sorry, I did not send the Clio. No,
Good.
sorry. Okay.
How about
Thank you all.
All right,
Okay.
everyone.
Bye.
Bye.
Take care.
Bye-bye.